This video is brought to you by OKCoin Crypto Exchange, where you can buy, sell, and trade your favorite cryptocurrencies, and you don't have to pay high fees. OKCoin has very low fees, lower than many of the other crypto exchanges in the market. You can also stake your cryptocurrencies and keep 100% of the rewards. There are no fees. Other exchanges charge fees. OKCoin allows you to keep 100% of the rewards. Sign up with OKCoin, link in the description. Hi, everyone. Welcome back to the Thinking Crypto channel, your home for crypto news and interviews. With me today is attorney John Deaton. John, great to have you on.
Hey, Tony, how are you doing? Thank you.
Well, John, I want to say a big thank you for the work you're doing on behalf of XRP holders. And we got a lot to discuss today. Let's start with the state of the union on what's happening overall with this lawsuit. And then we'll lead up to the big win we got from the judge giving us amicus.
Well, right now, what's going on is behind the scenes, expert disclosures are about to go down where, Ripple will disclose soon their expert witnesses. For example, I would expect that David Schwartz will be one of their expert witnesses, and then they'll have probably, this is me speculating, but they'll have someone independent of Ripple who's an expert in blockchain, expert sort of in decentralized protocols, things of that nature. So that's what's sort of happening behind the scenes. I believe there's still an extension in place for depositions for Brad and Chris and things of that nature. And really the big news, other than XRP holders being granted amicus standing, is, the in-camera review that Judge Netburn is ongoing, where she's reviewing these documents and she's going to give a decision whether or not the documents that the SEC are claiming are privileged are in fact privileged and Ripple doesn't get to them, or she's going to declare that they're not privileged, right, and that Ripple gets them, or she's going to declare that some are privileged and some are not privileged, and there will be a partial disclosure. And it's also possible that she could say that there's a privilege, like the deliberative process privilege applies, or an attorney-client privilege applies to certain documents. But because they're so relevant and probative to the central issues in the case, she's going to pierce the privilege and rule that they're still admissible, because there's no other way for, say, Ripple to acquire that type of evidence, Sure. So, as an example, we know that there was a 2013 document. It was actually transmitted to SEC employees and emailed throughout the SEC. That was a legal analysis of XRP. Basically, some lawyers at the SEC sat down and they made an analysis. Is XRP a security or not a security, right? Mm-hmm. And Jeremy Hogan pointed out, rightfully so, that, you got to assume that if the finding of the SEC attorneys was XRP is definitely a security, right? And that was June 13th, 2018, I should say. If that's the decision, then why wouldn't they turn that over to Ripple? They would still have to explain, why they took so long to bring a lawsuit. They could make that, answer pretty easily, to be honest with you. Investigations take a long time. Most likely, it probably says XRP is, we struggle to meet this factor of the Howey test, whether it's the common enterprise or whether it's the expectation of profits or whatever it is. And then, of course, that would be really probative to Ripple for their fair notice defense. And so we know that exists. We know there was an email chain that the SEC communicated with a third party that was explaining to them how to analyze their digital asset with relative to the Hinman speech. Is that Ether? Is that someone else? We don't know because they don't tell us, right? Those things are sealed. So
now, quick question on that respective analysis that was done, because around that time, a lot of people were waiting for Coinbase to list XRP. Now, I've seen, and I remember back in that time, folks from there and went on CNBC, they kind of alluded to securities laws without saying XRP was a security, but that might be the roadblock or hurdle. Do you think that the fact that Coinbase went ahead and listed XRP, they got some level of clarity somewhere that, hey, XRP is not a security?
Well, that's a great question because, Tony, what you're talking about right now is one of the biggest pieces of evidence in this case, all right, as it relates to Ripple. Now, in the documents that have been turned over, we know that Platform A, as it's written in the memorandum, went to the SEC, and it's an exchange, and informed the SEC that they were going to list XRP. And after that meeting, they went ahead and did it. And we know that meeting took place in early January of 2019. Now, this is John Deaton speculating, so let me make that clear. But I looked up and, did a quick Google search, and on February 28th is when XRP, February 28th of 2019, was listed. So when you look at the dates, I believe Platform A is Coinbase, right? And so it's a big piece of evidence because Coinbase was working with the SEC. The SEC came out with this framework on how to analyze a digital asset. All right, except the SEC's framework didn't have weighted factors, didn't assign like weight points or whatever to each factor. The Coinbase took that framework and then improved it and came up with these factors. So I believe the evidence is going to be this, that Coinbase went to the SEC in January of 2019 and said, we have done a legal analysis and we conclude that XRP is not a security. We also have an independent law firm analysis that XRP is not a security. We plan to list XRP. What do you say, SEC? Now, I don't know what the SEC said, but we all know what the SEC didn't say. They didn't say, we believe XRP is a security. They didn't say, hey, you better hesitate. You want to go public soon. You better not put that security on your platform, buddy, right? They didn't say any of that stuff.
Right.
They came out and whatever happened, whatever language was used in that meeting, Coinbase listed XRP 30 days later. Right. So that's big evidence for Ripple, for XRP holders to say, hey, Coinbase has a very good legal team, right? Brian Brooks, who ended up becoming the comptroller of the United States, used to be counsel for Coinbase. They're very sophisticated when it comes to securities laws, and they determined XRP is not a security. When they do that, what does that signal to Ripple, to you, to me, right? Hey,
right.
It's got to be good. They've been allowing it to be traded for all these years, and now Coinbase is put it on their platform. So it's a huge piece of evidence.
Now, let's talk about the judge granting amicus. What does that mean for XRP holders and the path forward?
All right. Thank you for having me on because, some of these articles that you read online, whether it's CoinDesk or someone, I don't know who writes these things, right? Because the lead tagline will be judge denies XRP holders motion to intervene. And they minimize what a big deal this is, right?
Right.
And I'll tell you why if you look at when I went on Fox with Charlie Gasparino on the Liz Clayman show, I went on Friday before the Monday where the decision came out. And I literally said on TV, I said, look, we're asking to be named as defendants. That's a very extraordinary thing to do. I literally filed a lawsuit that said to the judge or motion, we want to be sued by the SEC to judge, because in essence, they've already sued us. So we might as well be officially a part of the case. Not many investors go to prosecutors and say, sue me too, right? So these legal experts, they're like, oh, his motion was denied. I don't know if they've ever had a moment of strategy in their life. It's signaling a thing. But what I said on Fox was, we're asking to be actual parties, but in the alternative, the judge maybe can grant us amicus standing where we're allowed to participate with brief writing or, motion practice, things of that nature. And that's exactly what she did. And so, I have no problem with the judge's ruling. I expected it. I believe that she could have granted the individual XRP holders who are named in the motion. She could have granted us status, but what the SEC said in their opposition was that if she grants it, they're going to seek discovery against us. Now, between you and me, Tony, we could give them, if I have 6 XRP holders who are the named parties, we could say, here's the screenshots of their trades. Prove that they own XRP, prove that, this isn't made up, right? That they have standing. But, that was the SEC's way of saying this case is going to get delayed because we have a right to seek discovery and do this or do that. So the judge did the right thing. I did have a case where I cited to the judge. It's happened in the past, but it usually happens in a family situation. For example, in my brief, I found a case out of Florida in the 8th Circuit where a husband was sued by the SEC and the wife came in and said, hey, that's my property too. You need to name me as a defendant too, so that I can defend this case, right? And so if you look at the judge's ruling in our case, she said that there was no case law on what I was asking the court to do in a non-family kind of situation, right? And so it was a great decision by the judge.
Yeah, I mean, it's unprecedented. To your point, has not been done before. And now I believe, if I'm not mistaken, the number of signatures, is it over 35,000, 36,000? The number keeps growing every day.
Yeah, it's earlier today, I checked on it and it was like 38,600 and some, people have signed up. What's interesting now about this, and I didn't see this coming, but it makes perfect sense, is I'm obviously, 99% are XRP holders, right? But I'm seeing some people out of those 38,000, there's a few hundred now that are like, hey, I don't own XRP. And to be honest with you, they write it in the comments section, which you don't have to, but some people do. They're like, matter of fact, I can't stand Ripple, and I never owned XRP and I never will, but I'm offended by what the SEC is doing, and I want to be part of this. And so that's extraordinary because it's people are finally getting what this case is about, and it's much bigger than XRP and Ripple. You know what I mean?
Absolutely. So, John, essentially, you are what the judge granted. You are representative for all the respective XRP holders. And what will be the dynamic of your participation now? And will it be you providing further evidence, answering questions, and providing guidance and things like that?
Yeah. Now, one of the things that I had asked for was that to be granted amicus standing with participatory rights, where I wanted to participate in the case. And the judge allowed that, but she also limited it where she said, listen, I'm not going to let Deaton, put on live witnesses at the trial, right? And things like that. Because she said Ripple can do that. In other words, if you look at the, actually, it's on page 7 of the order. She says that Ripple has the motive and the means to do what I would do if I were actively litigating it at the trial. In fact, the judge even said Ripple could depose the XRP holders. Right now, that's interesting because the fact discovery deadline has passed in the case. So that's something that's very interesting that I'm probably going to meet soon with attorneys involved in the case and figure out, what's the avenue for that. But I do know that several XRP holders, they'll probably be using me as a conduit. You know what I mean? To get affidavits and things of that nature, right? So if someone has, like James Rule XRP and others use the uphold card and they use XRP as a substitute for fiat and they get paid in XRP, they buy their groceries in XRP. So probably accumulating affidavits of that nature, right? I might be reaching out to you, my friend, saying, hey, are you willing to sign an affidavit that says that some, doesn't matter what percentage, but that you have acquired some XRP in your business, right? Or your podcast or your YouTube.
Oh, for sure. Yeah.
And people have said, hey, I appreciate the content that Tony gives me. Here's a few XRPs, to help contribute because I want to for your channel to thrive. And then you use some of that XRP, maybe you cash a little bit out for a microphone or something like that. So that's an example where XRP holders such as yourself, yes, you're an investor, no doubt about it. And you bought XRP, you look at it, just like you said before, you own some Bitcoin or you own some Ethereum or Cardano or whatever. And it is an investment, but you also acquire it for non-investment reasons, right? So it could be you or Crypto Eddie or the guys on the chain, you know what I mean? Or others where I'm like, hey, are you willing to sign an affidavit? And then, of course, it's up to you whether you are. And so I've made it clear to people they can join and it's anonymous. And then there's people that are willing to sort of put their name out there. They will have an opportunity to do that. So there'll be some of that going on in the real near future as well.
Awesome. So should we go through the respective order document?
Sure. What I think would be helpful is why don't we pull it up? Because I'm really impressed with these judges. So if you pull up the order, you see there, thank you for pulling it up, Tony. You can see there where it lists individual names. You see my daughter's names right there at the front, Jordan Deaton.
Oh, wow. Yeah.
Right. But you see the language there after the names, all similarly situated XRP holders. Basically, that's signaling to the court that here's a few of the names that we're asking to be the parties, but I'm also representing all these other XRP holders. Now, when I filed this motion, it was 12,500 people. Then it grew to, 15,000, and then it grew to 25,000. Now it's, pushing 40,000. And so at some point when I file the next document with the court, I will go on record to say, Judge, I now represent whatever it is at that moment in time that I write the motion or the pleading, right? Whether it's 40,000, 50,000, whatever it might be, to let her know that that's the extent of the public interest here. It's extraordinary. We're talking about tens of thousands of people are joining because of the impact that it has on them. So, but I just wanted to explain that for people. Now, if you go to the second page, Tony, it's something I tweeted today. It's going to be on page 2 at the top, right? And the judge here, this is very good. You see where it says, as part of these allegations, the SEC contends. You see that? It's like the third or fourth line.
Yep. As part, I'll highlight that here.
As part of these allegations, the SEC contends that defendants, that's Ripple, created a secondary market wherein individuals who purchased XRP from defendants resold the XRP to others. And then it goes on and says, including on independent trading platforms. And it mentions, people that are not affiliated with defendants. This is a great sign to me that the judges get this, right? Judge Netburn and Judge Torres, they've been great judges, man. And she gets this because this is an extraordinary claim. I mean, they're basically saying that Ripple created, this is her citing the SEC. The SEC claims that Ripple created the entire secondary market and that when Ripple sold XRP, or Brad Garlinghouse did, to Coinbase or whoever, and then they sold it to John Deaton or Tony, that all of that is part of the case. And then as you can see there, as it goes on, the next line, and that XRP holders invested in common enterprise. When you take that language, the judge is relying on the complaint where the SEC says that all XRP is a security, including the XRP traded in the secondary market, right? And the judge is acknowledging that is a significant issue. And then you'll see here at the second paragraph where it says movements contend. See the second, let's go down to the second sentence. Movements, that's us, argue that the SEC claim that the very nature of XRP itself is a security. Right there. Movements argue that the SEC's claim, the very nature of XRP itself makes it a security, leads to the conclusion that, quote, every individual in the world is selling XRP would be committing a Section 5 violation. That's another significant thing the judge wrote, because who else said that, Tony? Judge Netburn, when she questioned the Jorge Tenrero for the SEC, she said, well, according to what you're arguing, every person in the world selling XRP is violating Section 5 of the Securities Act, right? And so the judge is acknowledging these arguments, and this is what made me feel good, even though, she didn't give me everything I wanted, right? But right, and maybe she shouldn't have, right? I don't disagree with ultimately what she found, but this was very basically reassuring to me, because you always wonder, do the judges really get the impact that this is having? This is not a very easily understood area, blockchain technology, and it's software code. It's what is sufficiently decentralized, and nodes and validators, right? It might as well be a foreign language to a lot of people. And so, but I'm very impressed.
And just the thought of this, it's as more and more I read this, that every XRP everywhere is a security. It's ridiculous. Like my mom, who doesn't understand anything of this, she wanted to invest in Bitcoin and so forth. Guess what? She holds some XRP. Yep. If I go to my mom and say, hey, you're selling and buying and selling on security, she's gonna be like, what are you talking about? Like, what?
Yeah. And the judge went on to, like, if you go to page 5, Tony, she cites up there a case called Cheney. You'll see it there in italics. It's Heckler v. Cheney. That's from the Supreme Court. And basically she was saying, listen, the Supreme Court of the United States has found that when people have tried to bring an action against the SEC because they didn't bring a prosecution, the Supreme Court said you can't do that. Like, the court can't tell the SEC who to prosecute and who not to prosecute. See, we get into separation of powers, right? The court system is it's an Article III judge. You have separation of powers. The SEC is part of the executive branch. And so, for example, if Ripple tried to bring Jed McCaleb in and claim that he was an indispensable party, there's case law that says you can't do that. So that's why that the second paragraph, it says there is no case law that addresses the specific circumstances presented here, where an unrelated individual seeks to intervene as defendant. Basically, in all of this language, she's saying, listen, you know, if you can't force the SEC to sue someone that you think is an indispensable person, if, like, in other words, if Ripple couldn't force them to bring in Jed McCaleb, then I really don't think I have the authority to force the SEC to sue, you know, Jordan Deaton or any of these other people, or the 50,000 people that want to, you know, are willing to be sued. And so that's really all she was getting at. It's very well reasoned argument. And I want to show you go down to the page 5, where at the end where it says, even if the allegations in the complaint, you see that?
Oh, yeah.
This is the judge, again, a great line where she's acknowledging what we're saying. Even if the allegations in the complaint are as far reaching as movements contend, we're not currently defendants and our hands are sort of tied. But that's her saying, listen, I hear what you're saying, right? You're claiming that this complaint is so far reaching that in essence, the SEC really did sue you. And I'm not going to let you become defendants because I don't think I can do that. But I do have the power to let you be heard. And then that's ultimately what she did. If we go to, we're not going to go through the whole thing, of course, but sure. if you go to, you know, page 9, that's where she says at the very top there, movements shall, however, be permitted to act as Amici curiae. Now, if you go to page 10, at the very top, this is what I believe either Stuart Alderati or Brad Garlinghouse tweeted. I can't remember who, but you know, this is great language here from the court, where you see there at the very, after unavailable at the very top, Tony, they, that's us, that's you and me. They will provide the court with a meaningful perspective and will help ensure complete and plenary presentation of difficult issues so that the court may reach a proper decision. That's basically saying by this judge that she finds that we have a meaningful perspective that deserves to be heard. And she's going to make sure that she hears that perspective and that she considers that perspective. And that's just great language from a court. You know, she's not going to comment, hey, I think the XRP holders make a good case or anything like that, right? That's just not how a judge, an unbiased judge, they stay neutral right down the middle. Sure. But this is a great recognition of that we have standing to be heard. We deserve to be heard. And she needs to consider that. And then if you look at the last sentence of that first paragraph, the court views, you see that? She's citing a case where she says, the court views the amici briefs as desirable because they represent third parties whose particular interests may be affected by the court's ruling and whose particular interests are echoed in broader public interest. That's her citing a case that cites that language where she's recognizing that there's a huge public interest in this case, and she's going to allow, in her words, from the court's perspective, she's calling what we have to offer is desirable for her to hear, right? Now, she can always reject whatever I brief, right? Anything that I give to the court, if she finds it unreliable or she finds it unpersuasive, she doesn't have to consider it, right? Or she can consider it, just give it no, weight or credibility. But this is the court really basically saying that we're going to assist the court. And she finally uses that language. The last thing I'd highlight is just above the conclusion on page 11. That second sentence of the second paragraph before conclusion. As such, movements shall be allowed to assist the court by briefing legal issues relevant to the case as approved in advance by the court. So she's recognizing us what Amici stands for, which stands for Friends of the Court, right? And this is a judge reaching out and saying that that not only should she hear what we have to say, but she needs to hear what we have to say for her to be comfortable in whatever decision she makes, because she wants to make the best decision she can. And if it's going to impact tens of thousands of, individual XRP holders or the entire crypto market, she wants to hear what we have to say. And so outstanding. I mean, there's lots of things in there I like, where she smacked down the argument by the SEC that said that we're not neutral parties, right? I remember when they argued that, I tweeted out, you might want to review a little bit of the case law, because, in abortion cases, Planned Parenthood writes amicus briefs. Right to Life writes amicus briefs. These are all people that have a particular bias, but the court always acknowledges, and potentially will consider what they have to say. So big victory for XRP holders. And I'm really excited and pleased about it, because I think it was ultimately the right decision. Listen, we're all got our things, I got an ego and I'm competitive. And do I want to be in court? And do I want to call you live or call Spin the Bits live and do a presentation to the court and how Spin the Bits uses XRP to transport Bitcoin, right? But the Bitcoin's not a security, but the 0.00005 XRP that was burned to move the Bitcoin, that is the security. Like, I'd love to do that. But we'll get it in one way or the other. So ultimately it was a great decision.
Yeah. Congrats, John. And thank you once again for, what you're doing on behalf of XRP holders. And this is certainly a big win. I do want to talk about Charles Gasparino. I know you've been in contact with him and the folks at Fox Business. I know one of the things they said they were going to look into was the potential conflicts of interest with William Hinman and Jay Clayton. Any updates on that and anything you see that's on the horizon?
No, I don't have any particular. I'm glad you bring it up, because I do want to address this, right, with the XRP holders. Listen, guys, everybody out there, I know that you all have lived with this. You know the story, and they have to understand, because I've come to learn this, right, that not every single fact is come out the way that it should, right? For example, I know for a fact, obviously, that Ripple was created after the XRP ledger and the XRP was created, right? But when I have 1 or 2 minutes of airtime, right, I'm not going to correct those. I'm not going to waste it saying, well, technically this existed before, right? That's up to the Ripple lawyer. Ripple lawyers do that, right? I'm not here to defend Ripple every time I get an opportunity, right? I'm here to shed light on what's going on. And so I know that people get frustrated, right? Like, why didn't John say this? And why didn't he correct Charlie Gasparino when he said this or he said that? And, you just have to pick your battles and accept that although it may not come out exactly the way XRP holders want, before Charlie and Eleanor got involved, before, you know, Digital Asset Investor tagged them and we started going back and forth, there was no coverage.
Nothing.
Right? There was nothing, right? There was a little bit here, a little bit there, but no one that was really paying attention. Nobody was acknowledging conflicts of interest except for, you know, the New York Times article cited me and said, well, there are claims of it, but no one was asking questions. No one was inviting Bill Hinman and Jay Clayton to come on live TV and answer these questions. And so we just got to be happy that that's happening, right? And I believe they're going to follow up on it because I don't know Charlie Gasparino or Eleanor personally. Behind the scenes, I've had a few contacts with them, very professional people. I don't see them letting it go. Like, they'll still follow the case. And I think that Charlie, when he says, listen, I've met Jay Clayton, he seems like a nice guy. I know that drives people crazy, right? Listen, that's his experience. And we want a reporter or a journalist to go in very, like, I'm going to give Hinman the benefit of the doubt. Yeah. I'm going to give Clayton the benefit of the doubt. Hey, there's been a revolving door at the SEC for years. What they did in this case is probably no different than whatever happens all the time, right? Let them have that perspective, because if they do reach the conclusion that maybe you've reached, or maybe that I've reached, or some of the XRP holders have reached, then it's even better, right? Because they were coming in there with sort of that hesitation, you know, where Charlie says, you know, sometimes there's smoke, but there's not a fire, right? Well, the counter to that, of course, is a lot of times there's fire, though. But I'm not going to challenge that, right? I'm happy that they're covering the story, and even if they don't get every little fact right.
That's absolutely a great point. I mean, because we've seen Jay Clayton and these guys go on CNBC and these different shows, not a question about these things, but the fact that we're getting coverage now is a big win. And I think it'll continue to get picked up, because I think they're now seeing the activity, all the 30,000 plus or hundreds of thousands of XRP holders talking about it now.
No, absolutely. But I believe there'll be more follow-up. You know, how much, I don't know. You know, Charlie's got a lot of things that he's probably working on. But I know that this interests him. And I know that, you know, it was a great find when Digital Asset Investor found that, because he really was, in May of 2018, it was right at the beginning of this. You know, it was only a month before the Hinman speech where Joe Lubin and everyone's talking about, hey, we're working with regulators and we got this alliance going on with the SEC, and we're going to maybe even have be a self-regulatory body that's sanctioned by the SEC. Charlie reported all on that. Little did he know that in 2018, when he was reporting on that he might have been reporting on one of the biggest financial insider stories in recent history. And, you know, I know a lot of people feel that, as I've said to people, look what the XRP community has uncovered with publicly available data and information and videos and Google. Imagine the power of subpoena, right? Imagine the subpoena power, and you can get emails and text messages and phone records and things of that nature. And as I've said to Charlie, and I'll say it again, and I'll say it on national TV every time I get a chance, I'm not saying anyone broke the law. Right? Something could be legal, doesn't make it right. Right? That doesn't mean that's how we create policy in the United States of America, right? Even if it is legal, but there is enough, Tony, there's enough to have an independent investigation into it. And that's what we need, right? And
Absolutely.
someone who does, whether it's the Inspector General, whether it is Department of Justice, a U.S. Assistant U.S. Attorney that investigates it, give somebody the power of subpoena and let them go delve into some of these inside dealings and conversations and find out, how did Joe Lubin know, for example, that there would be no further declarations related to any other crypto other than Bitcoin and Ether? How do you know that? How did he know that soon there's a reckoning coming? How did Mike Novogratz know that they're going to pick one token and go after it real soon? And all of that transpires. Like, how do you know that? How is it possible that, when Jay Clayton gets up on TV and says, I didn't know any of these people when I was in office, right? It's like, what, you don't think we can check the record?
Right.
Your calendar, now, did he mean Apollo? Did he mean One River? Did he mean them all? I don't know, but it'll be interesting. What I'm really interested to see is does Hinman or Clayton, do they take an invitation and accept it of a Charlie, right? Are they willing to answer those questions? We'll see. You know what I mean?
John, there's so many intricacies with this story. I have to ask, any plans to write a book when this thing wraps up?
I don't have any plans to write a book. I think that right now, I just want to get an investigation or something into it, because, the way things just went down are just not the way it's supposed to be. You know what I mean? It's like I said, let's say that an investigation does take place. And let's say at the end of the investigation, they say no criminal activity took place, no criminal charges. Okay. But is that the way we do business in the United States? You know what I mean? And it's just demoralizing, right? And as I keep telling people, they read these stories, man, of like people who've done their due diligence, and they look at things and they say, oh, wow, the SEC allowed Ripple to buy 9% of MoneyGram. All right. I mean, they're using XRP for cross-border payments. I'm going to buy XRP because of that. Exactly. Right? Because I've got people who did it just because of that. Right. And then you're going to turn around and say, 2 years after you allowed that to happen, that even though that Ripple was transferring XRP to MoneyGram, and that MoneyGram's not a hodler, and that they were going to sell it on the exchanges, who were then going to sell it to me or you, that all of that's a security now? Come on. Like, Gary Gensler is famous for saying, if it looks like a duck, quacks like a duck, walks like a duck, it's a duck. Well, if it looks shady and smells shady, acts shady, it's probably shady. You know what I mean? So, but right now, I just want an investigation to be started as far as the conflicts, and I want resolution on, the XRP we hold, right? Yep. Because, listen, if XRP was deemed a security, pretty sure Chris Larson and Brad Garlinghouse, they're going to be okay. You know what I mean? But, what about the people that have $50,000 invested in it, and it's their entire life savings? Right. What about them? And that's the stuff that they've got to realize of the impact that they're having. I have, Tony, I'll give you an example, right? I have a group of XRP holders, elderly women, right? Mm-hmm. They're between 65 and 75 years old. I think one of them's 80. And they got together, and, one of them, they got a little investment club together, right? And they heard this thing called Bitcoin that their grandkids were talking about. You know, they have a little investment club in the meeting, and like, you know, my grandson's talking about this Bitcoin. And then they start like looking into it, and God bless them, right? These elderly people who are like, hey, even though I'm 75, I see this new asset class developing. And I don't know anything about it, but, you know, let's pull our money together in our investment club, come up with, you know, $75,000 between us. And you know what? Let's just buy the top 3 cryptos. And that's what they did.
And John, I didn't mean to interrupt you. When I was talking about my mom earlier, she has Bitcoin, Ethereum, and XRP. And guess what? She's never invested in stocks or anything before. She just knows, oh, my son is in crypto, and I see this on TV.
No, exactly. And so they never heard of Ripple. They never heard of Brad, Garlinghouse, Chris Larson. They're an elderly investment club. They're putting their money in. They're talking about it. They invest in this investment, this new asset class, and they just pick the top 3. And they're like, hey, let's diversify.
Yep.
And you're gonna call what they bought an unregistered security, right? They've never heard of this company, and you're going to say that they're in a common enterprise with Brad Garlinghouse, right? Come on, you see, that stuff gets me like, you know, it's probably good I'm not in court, right? Because I start thinking about those things, man, and it's like it just gets my blood boiling that our government will do that for what? For political reasons, or because you want to be the most aggressive you can against Ripple and try to make them hurt them business as much as possible in order to get them to settle. In the meantime, all these people that are innocent, you know, are being negatively impacted, and your mission is to protect them, and you just don't give a, you know what? You know, so that's the stuff. People ask me what motivates me. That's what motivates me. Your mom motivates me. You know what I mean? I'm just being honest. You know,
no, for sure.
Her son's out there. He's like giving up his job to go into this new area, and he's taking this risk, and he's got this podcast, and he's talking about this XRP, and she wants to participate. It's like being part with her son, like, right? And yep. You're gonna hold up her XRP, right? Just go after Ripple and say in 2013 and in 2015, when you sold it back then, it was a unregistered security because it looked a lot different back then than it does today. Fine, do it. Whether they gave Ether a pass and whether that's fair or unfair, Tony, to be honest with you, I don't give a shit. Right? Like, right. Whatever. I wouldn't be involved. I wouldn't be filing these motions. I wouldn't be doing all of this if that's what they did. But that's not what they did, and it's wrong. And they need to answer for that.
Absolutely. Final question here before we wrap it up. I'm going to be interviewing Hester Peirce, SEC commissioner, this week. Now, she's boldly...
Can I be on your shoulder?
She's boldly come out taking a stance complete opposite of what Gensler has been parading on TV and saying. What do you think about this? It's an interesting dynamic, and then when the question they come up, that did he actually read the safe harbor proposal that she put together?
Well, she probably would, wants to stay away from Deaton all she can, right? With what I'm doing, but God bless her. Like, God bless her. She could be just sitting in her chair and keeping about her business, but I think that she cares, and I think she's been courageous. And there's no doubt that she's probably taken some flack for making these public statements, but God bless her because she believes in it, right? And I think we need people to do that more in our government, where, she's not being disrespectful, right? She's not saying anything bad about Gary Gensler. She's saying, I disagree with, the chairman on this issue, and I don't think we've been clear and all those things. So I think that she's playing her part as well. I think the fact that Gary Gensler has not read her safe harbor proposal is all you need to know. I think that says everything you need to know about where Gary Gensler's head is when it comes to crypto. And so how do you not read that, right? Okay, so say you disagree with it, but how do you not read it? It's part of this whole history. She proposed a safe harbor at the same time, except her proposal was for everyone, not just Ether, right? Yeah. And how do you not take that into consideration? It's the only way to go, right?
Right.
You have this period of time. If you're not sufficiently decentralized, you could even come out with guidance. Listen, if the SEC wanted to say that, that not one entity should own more than 25%, right? At least come out and say it, and say to Ripple, we're going to hold that against you because, you own over 50% of the outstanding XRP, but at least provide some type of guidance. And I think that my perception of her is, and maybe you'll get to find out when you interview her, is that she's got to be one of the most frustrated people in any workplace, right? And you can even ask her it that way if you want. Like she's got to be really frustrated because, she works for, right now in the crypto community, probably the most despised U.S. agency that there is. Yep. Yet she has been trying her best to do the right thing. Like, let's make sure we enforce the securities laws, but do it in a sensible way. And she's been hitting, brick walls. I think when you interviewed her last time, I think she may have said sometimes it's like talking to a wall, or I'm on an island by myself. You know what I mean? Yeah. So it's great for you though. That's great. I'm sure you'll push her where you can. You know what I mean? But she's obviously not going to make a lot of specific comments on. The one thing I'd say though is the thing I cited. I don't know if I told you this before, but I actually cited your interview of her in the legal memorandum in my motion to intervene. In my reply brief, where I was saying to the court that the SEC is treating XRP as a token, the asset itself, and that's not how you're supposed to analyze it, right? And I cited where she said to you, I'm trying to get the SEC away from thinking of the digital asset as the security, and it's the scheme and the way it's marketed and packaged and sold. But one thing that I'd probably ask her is that when Gary Gensler is asked about Bitcoin or Ethereum, right? Why can't he just simply answer it the right way, which is, listen, any asset can become a security if you package it and scheme it into a security, right? Right. But the asset itself, Bitcoin itself, Ethereum itself, XRP itself, Cardano itself, whatever, that underlying asset is not inherently a security.
John,
right?
John, you mean the oranges in the supermarket and what I have in my house? Yeah. Those are securities?
That's according to right now. If you went back in time, listen, what I would like to do, of course, she's never going to comment on the Ripple case, and I accept that. But the paragraphs, Tony, in this complaint, like I tweeted something out earlier, people need to read the complaint where it says the very nature of XRP as constructed by Ripple is the common thread of the common enterprise between Ripple, its management, and all XRP holders in the world. I mean, the only thing they left out is in the world, right? I added that just now, but when you read that kind of stuff, you're like, what? The asset itself. So the absolute truth would be Go back to 1946, and an SEC lawyer is saying to the judge, these oranges are investment contracts with the W.J. Howie Company. It's the same thing that they're saying right now. They're saying that the XRP that Tony's mom bought, who's never heard of Brad Garlinghouse,
nope.
That the XRP that she bought off Coinbase or OKCoin or whoever, right? That is an investment contract with the company she never heard of. It's the same thing. And I know that Hester is doing her best to get them away from that. And so God bless her, though.
Well, John, thank you so much once again for all you've been doing. And I don't know how one day maybe we'll meet up. I owe you a steak dinner.
No, you don't owe me anything, man. You're doing your part too. Trust me. I appreciate you inviting me on. And I apologize if I went off on a rant or something like that.
No, this is a great discussion. And it's I feel the same way. My blood boils reading some of these things. And it's like you apply logic and reason to this. It's like, what is going on? But thank you for fighting the good fight. And I appreciate you taking the time to do this.
All right. Thank you, man. I appreciate it. Thanks for having me. See you next time.